everybody has an estate. If you own property, you have an estate. It may sound a bit odd, but that is legally an estate is any amount of property. So just because you hear somebody say, oh, I have an estate plan, don't think, well, I don't need one of those because I don't have a large estate. That's not accurate. If you own property, specifically if you own real estate, or if you if you own real estate or own children, was what I was about to say. If you have children, then those are the major reasons for doing estate planning. Now that we know what an estate is, let's talk about it for a second. Why do we do estate planning? Why do clients come to see me? And what is it that, part of your life that you need to sit down with a lawyer and talk about estate planning? The basics of it are that it provides some sort of certainty. Without sitting down to do a will or some document similar, your estate is going to pass to anybody, or it's going to pass according to law. Okay, so that includes your children. Who is going to get custody of the minor children? And custody meaning who's going to make the legal decisions. Do they get up and go to school every day? What school do they go to? What are they, are they going to get jobs? Are they, every decision with a child's life, is made by their parents. If their parents are not around, then you have to have a legal guardian who's responsible for the child and also to help raise the child. If you don't make the plans for that, and you don't talk about who you want to raise your children, the government will make that decision for you. We do not want the government making decisions about raising our children. That's never a good thing. The law in Idaho has lays it out, and so that if you don't have a will, that's a concept called intestate, and what it means is just basically that there are some laws in place that states have passed. And by the way, this is different in every single state. So, well, I shouldn't say it's different in every single state. Let me qualify that. Idaho follows what's called the Uniform Probate Code. That is a code that's been adopted by many, many states. And so it's very similar from state to state, but this is state law. It's not a federal thing. Every state passes some sort of, probate and wills and trusts and things like that. So it's very state specific as to where you are. So Idaho's may be different than, some other state. If you're familiar with, you've got family. Oh, I had mom and dad, and, this is the way it went in California. It may be different in Idaho. Actually, California and Idaho are somewhere, but something like that. Just because you hear about something that happened in another state, it doesn't necessarily mean it's the same here in Idaho. But anyway, so going back to what I was saying, why do we plan? Why do we do this? It's for the certainty. There are also some other considerations that can be had where you can do some tax avoidance as well. If you believe that you have an estate that is subject to tax, which, by the way, that is a moving target, and that is a common question we always get when we talk about taxes. There are estate taxes, or death taxes, people call them, is the government taking a piece of probate, a piece of the state that goes by. Idaho does not do that. It's usually it's federal government type situation. That number moves drastically based upon who's in control of the government at the time. Typically, when we have liberal government, right now we have a Democrat president and two Democrat-controlled, Senate and House. We have a tendency to see those state taxes go up. When the conservatives are, in charge, we have Republicans there. They have a tendency to bring those taxes down or to get rid of those. I shouldn't say get rid of them. They never get rid of them. It's just a number. And so if your estate equals $20 million, then that's when it kicks in. Okay, if you have $20 million that you're going to pass to your children, we're going to take a piece of that as the federal government. That's what estate taxes are. Like I said, that number goes way high when there's Republicans. It goes way low when there's Democrats. They'll tax at a different level. So that it's always a moving target as to what it is. Most people right now in America are not going to be looking at estate taxes because that number is very high. But like I said, it can move at any given time, and it probably will here in the future. And because we're recording this, I am not going to give you that number right now. Google it. It's very simple. You can find it, but it will change. So that's another reason that we do planning, and why we want to have our ducks in a row, so to speak. One of the other situations is that it can take longer. If you have intestate, which I said before, is if you die without a will and you don't plan, it can take longer to get things figured out and figure out where the property is going to go. And so wills can make the process much, much quicker. But then, like I said, at the outset of this, we always provide a guardianship for any minor children in the wills as well. But that is probably the number one reason folks will come to see me. They're young adults, and they're going through life, and this could be good advice for you guys out there as realtors. You're always with those couples that are buying their first home. One of the things that motivates them to move out of their apartment or mom and dad's basement is, if there's a kid coming. So, one of those things you might want to bring up is say, hey, by the way, now that you got your house and I've found this great property for you, don't forget to make some estate planning to take care of the child if something should happen to the two of you. So it's good to toss that out there. So now that we talk about why we've done, let's talk about what's typically included. What you will see in a basic estate planning package, there are 3 documents that are typically included. One is obviously the will. That's the major document, and I'll talk about that in a little bit. There's a living will, and there's a durable power of attorney for healthcare. So let's talk about each one of them for a second. The durable power of attorney for healthcare is just that. I mean, if you break it down, durable power of attorney for healthcare. So the durable part means that you all know what a power of attorney is, or you should. I mean, if you're doing real estate and you're licensed here, a lot of people probably have experience with powers of attorney. That is just a legal document that somebody signs that says, I'm going to give my power to somebody, not an attorney necessarily. It's kind of misunderstood, but it's just, I'm going to give the power. I'm going to sign it. And I'm going to say, I, Jason Risch, give Cindy Hunter my power to do what I could do, and so she can act in my stead. Those can be very general and wide open, or they can be very limited. A durable power of attorney for healthcare is limited to just that, healthcare decisions. So, and then the durable part of it just means that it will survive your incompetency. So if I were to give Cindy my power of attorney and it wasn't durable, if I suffered from Alzheimer's or dementia and I'm unable to make my own decisions, then neither is Cindy able to make those decisions for me, unless I make it durable, which means it will survive my incompetency. That's all the durable part means. So the power of attorney for healthcare. So this is a document that you're going to sign that, basically it says that when I go into the hospital, if there's, and this doesn't have to be, life, end of life or anything like that. These aren't the decisions like pull the plug type of deal. It can be very simple. If you're unconscious, you're unable to talk to a doctor and to give him medical advice or giving doctor medical advice, but, consenting to receiving treatment, or a doctor may have to make a choice and say, hey, we've got a choice here. We have to make a decision. Somebody has to do that for you. So the durable power of attorney is the legal document that gives somebody the power to do that. I'm using Cindy as my example. If I'm unconscious, I get in a car crash, I'm unconscious, I can't talk to the doctor. The doctor says, well, I need somebody who can make these decisions. I don't want to do that. I'm not going to do that. He goes to Cindy, and Cindy shows up and she says, yes, here's this piece of paper. And the doctor will rely on that. And the doctor says, okay, here's what I have to do. Jason's in risk of losing his leg. We can amputate, or we can perform this, very lengthy, expensive surgery. Which way would you like to go? Cindy will say, hopefully you're giving a power of attorney to somebody who knows you. And, she may say, well, oh my gosh, you can't possibly amputate Jason's leg. He's a marathon runner. That's what he lives for. He would want you to go above and beyond to save that leg. Obviously, that's not true. I'm not living and dying for running marathons, but that's an example I like to use because I think it kind of drives that point home. What does that document look like? If you've seen powers of attorney in your practice out there, it's not a whole lot different. It is it can just be a few pages long, and it talks about what powers are granted. If there's limitations, sometimes you can put those in powers of attorney for healthcare as well. So it's basically just somebody who's going to make those decisions for you. By law, it cannot be a doctor. You cannot have, or cannot be a hospital, a care facility. You're not allowed to appoint those individuals as your durable power of attorney for healthcare by law, because we want to basically, it's kind of a separation type situation. So that's what a durable power of attorney of healthcare looks like. You may see those out there, and they're a lot of them are just form driven. So you may even get them from doctors. Sometimes you go to a doctor's office, especially if you're undergoing surgery. They may ask you to fill one of those out along with a living will. So let's talk about the living will. That's the second document that I said that is typical in an estate planning package. A living will is a document that simply refers to the type of medical care you're going to receive, typically addressing what's going to happen in an end-of-life circumstance. This is the pull-the-plug document, for example. And so what you do is you sit down and you say, you think ahead of time and you say, hey, here's where I am. If you want to be the person who they take every extraordinary measure to try to keep you alive, even on ventilators and and forever. I mean, we've heard the nightmare stories that make the news where unfortunately people get sick and they get into a coma or something and they're in it for years, right? And the family may be fighting over, do we pull the plug? Do we not pull the plug? If you have a living will, that is a legal document that will govern that process. And if some family members say, no, we don't want to pull the plug, keep them alive, they would want it that way. The other family member who has a living will can produce a living will and say, no, they did not want to do this. They were kind of the pull the plug frame of mind. That's legally, and it can be very important to have that legal document. Practically speaking, this document is very, very important because it is something that gives some comfort to those who have to make that decision. We all are, every one of us is going to be in a situation where we have elderly folks that we're caring for, that we're involved with, be parents, grandparents, what have you. Somebody's going to be in that situation, and you have to make that decision. And if you're making that decision, wouldn't it be wonderful if that person had told you and had a conversation for you to say, hey, if I ever get in this situation, please pull the plug. I don't want to be around. I want to move on. I'm comfortable. Grandma says, hey, I've had a great life. I've lived a long time. I don't want to be that person that's causing problems or, stuck in a hospital on this ventilator, for decades. Practically speaking, it is a really, really difficult situation. I've seen this before with clients that are put in that situation. Even when you have it on paper, it's a very hard decision to make. When you have put it down on paper, though, and said, look, this is what I want to do, it really, really helps those folks that have to make that decision, because it's, like I said, very, very tough spot to be in. It typically will address life support issues, talk about whether you're going to receive food and hydration, through an IV. It also can deal with pain medication. A lot of people think that, well, if I sign one of these, or like a DNR, which is different, and I should probably touch on that for a sec. A DNR is a do not resuscitate. That's different than a living will. A living will is typically dealing with an end-of-life circumstance. Maybe somebody's terminally ill, they have cancer, they're going to die from it. What measures are we going to take? That's a living will. If you're on life support, it's required. A do not resuscitate is a completely different legal document. The DNR, as you hear a lot of people say, that is providing actually basically just CPR, and a living will won't really come into effect until it's critical. It's the end of life. You're going to die from this. A DNR, you could be choking on a piece of meat in a restaurant, and if you have a DNR, nobody's allowed to come in and give you compressions for CPR, and that there's some more details to it, but it may not be end of life. It literally could just be a Tuesday where you're having dinner and you have a problem. A DNR doesn't allow them to resuscitate you if you're in that circumstance. A lot of times DNRs come into play with living wills because we use them as folks get older, but you can have a DNR even when you're younger. And it really could be something very simple to say, hey, look, we can bring this guy back to life, get the thing, shock him, he's going to be fine, and he's going to live another 50 years. A DNR says, no, don't do that. So anyway, those are the difference between the two. There can be limits, and the pain medication, living will, that's addressed. And so what mine typically look like are, provide me all the pain comfort I can, that I can receive. A lot of people don't like medicine or they don't want medicine. You can put that in there, but mine, it doesn't have anything to do with pain, right? So it's always keep me comfortable. It's an end of life circumstance, either give me food, don't give me food, but always give me pain meds, right? Like that's always covered in there. So like every other legal documents, there can be limits to that, like I talked about with durable power of attorney for healthcare. So that's the the durable power of attorney for healthcare, and that's the living will. So I'm going to pause here for a second because I think I saw some chats pop up. Cindy, I don't have a screen where I'm able to read the chat. If you would,
Jason, we do have several questions. One was about the difference between the living will and the DNR. So you've already gone ahead and answered that for us. The other question is, a durable power of attorney for healthcare can't be a doctor. Would that include someone that is a doctor, but not your doctor?
Probably not. I'd have to look at that. That's a pretty specific question, and we can answer that very easily by looking at statute. I would be surprised if it prohibited any doctor. It's probably written that it's a care provider, and the idea is, like I said, we want separation. The separation of church and state. It's kind of the same thing. You don't want the guy who's making the decision, who's going to profit from the surgery, making the decision about whether or not you're going to go through surgery. So, yeah,
true. Okay. And
Okay.
I think those are the two that we've got for this section, so I'll let you
Great.
continue on. Thank you.
Okay. So then let's talk about wills now. What does a will look like? You know, what when we talk about that, what is it when we have a will? A will it can be very, very simple document. It can be very, very complex. Depends on what folks want to do with their planning. But a will is a document that addresses several things. Let's talk about first and foremost, it's going to address your property. And when I talk about property, we're talking about both real and personal property. You guys all know this, but personal property being, real property being real estate, personal property being literally everything else. So you will have typically sections that can address those and say, you can say, I want my personal property to go here. I want my real property to go there. You can deal with them all separately. A lot of people, when they make appointments with me and they say, I want to come in and do a will, but I'm trying to get the list of all my stuff. You actually don't need that anymore. That is sort of an archaic thing where you used to list out all of the assets. You had deeds, legal descriptions, and bills of sale. There were all kinds of complexities that used to go into planning a will, and that's a good thing to do if you're willing to go through that and you want to make it very detailed, very complex. That's great. List out all of your assets. Real property, personal property comes and goes over a lifetime, so it's not always it's unique to each circumstance, but it's not needed. You can literally say, I want all of my property to go to my son. You don't have to say, and by the way, I own 123 Main Street, and I own a cabin, and I own a car, and I own a gun. You don't even have to say that. You say, I want all of my property to go to my kid. That's it. That's really all you got to do. But us being lawyers, we make everything more complex than necessary. But it's never that simple. And actually, that's sort of a being, I probably shouldn't say that. It is necessary to have these formalities, although lots of wills I see are way overdone, so to speak. I'll talk about that in a minute when I get to trusts. But so the document can be, it can be 8 pages long, and it deals with several things that could come up. Like I said, we're going to talk about property, right? So in the will, we talk about, hey, I want my property to go here and there. Doesn't have to be divided equally. You can make specific bequests or general bequests, which is specific bequests saying, I have a son and a daughter. I want I want grandma's wedding ring to go to my daughter. That makes sense, right? So you can say that, and you actually say that in the will. You can have those provisions. You could say, I want grandpa's gun collection to go to my son because he's a hunter, or something of that nature. Those are called specific bequests, and you can do those. And actually, even in Idaho, we have a situation that makes that easy. In mine, I won't typically, something like a wedding ring that is going to be around or what have you, those are fine. Other personal property comes and goes. And so a will is not something that you are typically addressing every year, right? Like, I'm lucky if I can get people to think about it, to come in when they have kids and say, look, you really got to do this. So we get them in once, and then what'll happen is they'll do a will, and they won't even think about it for 10, 15 years, which is fine. So the way I do my drafting anyway is we make a reference to an external document. So my wills typically say, if I leave a written statement signed by myself that lists out property and where it's to go, that list will control first those specific lists, right? So that I can have a will and I can go home and I've actually had people do this. They go home and they make a list out of all this property, and this goes to that person, this goes to and the grandkids and the great grandkids, and they make sure every little thing is taken care of. If I put that in a will and they want to change that, then they got to come in and see me, right? And then when you do a change to a will, you have to amend the will. You create something called a codicil, which is basically a fancy lawyer term for amending a will. But we don't want to have to do that every time that something may change, right? Grandma goes through and she makes that list of everything. Well, she bumps a vase, it falls over and it breaks, and so it's not there anymore. Or it's something that's valuable that she ended up selling because she needed, to get the money for her care or something. All those are, those things happen to personal property frequently. So we don't always put those in the will because they will change. And so if we make a reference to a written document that is signed by an individual, it allows them to change it. And you can do that as often as you want to. You could have a particularly bad Thanksgiving dinner and want to get, say, I'm not leaving anything to my kids. You tear it all up, and then you feel bad, and a couple days go by, and okay, I'll make the list again and be good with it. That's when it comes to personal property. Real property, again, like I said, and you can do the same thing with real property. I want I want the cabin in McCall to go to my daughter. I want the home in Boise to go to my son. You can make those specific bequests. More typically, we see general bequests, and that is a will that where I will do something and it will say that I want all of my property to pass to my children in equal shares. And what you can account for in there, you could actually take that a few steps down. But what'll happen in that circumstance is that means the personal representative is going to gather up all the property. It just all goes equally. And if there's real estate, it can be sold, cashed out, and then it's divided 3 ways amongst all the heirs to the estate. So that's the difference between specific and general bequests. So that's what you'll see inside of a will. Also, if there's a charitable donation, if you want to say, I want to leave, a certain percentage to a church or a certain dollar amount to the church or a youth group or whatever nonprofit you want to think of, that's where that would go. That's how we deal with those specific bequests. Another thing that you see in a will is a section that relates to the children, like I talked about before. There is something called a guardian and a conservator. You can actually, you might see that in estate planning. So if you want to understand what that is, a guardian is the person who's in charge of the body, and a conservator is the person who's in charge of the estate, the money. So I may have somebody who I know that's going to be a great mom and dad for my kids. If something should happen to Jeanette and I, then I can say, well, we want this individual to raise our kids. However, they may be a great individual, but they're absolutely horrible with money, right? Like we don't want to entrust them with the money. So I can actually name somebody else and say, hey, I want the uncle who's a banker to be in charge of the money. And so he will actually get the money for the kids. He holds on to it. He doesn't decide anything about the kids, where they're going to go to school, what time they're going to get up in the morning, whether they're going to do their chores. That's the guardian. The conservator makes decisions relating to financial matters. Not typical that they're split up. Usually we just appoint a guardian and a conservator, or one individual to be, to have legal control over the children, to raise the children. And you can get very complex. Like I said, you can split these up. You can do it differently for different children. There's lots of different ways you can go with that. But that is a very important part of a will. And it's one of the main reasons I always advise people to, people ask me, do I really need a will? If you've got kids that are under the age of 18, yes, you do. And that's why. Because if you don't, like I said, the government's going to tell who's going to decide who raises your children. You do not want that. And we all know that, right? I mean, we know people who are good with kids. We know people who aren't. And there's people in your family that you would be like, hey, I trust, this brother with my kids. But this sister, she's just not good with kids. She doesn't like kids. Or she's, she spoils them rotten. She has no idea. She doesn't understand discipline. We all have those in the back of our minds. So just think about that. If the government doesn't make those decisions that way, right? They do it by law. They look it up and they go, who's the sister? Oh, okay, here you go. And they give them the kids and the money, and they don't care about, it gets more complex if you want to interfere with that, right? So if you say, look, I don't want the kids to go to my sister, I want them to go to my cousin instead, that would be a situation, right? So a situation the law would not account for. The law would say sister first, not cousin. Anyway, so that's the guardianship part of it, and that's a very important part of the will. Other things we see, burial instructions. I want to be buried in such and such cemetery. I want to be cremated. I want my funeral to look like this. Not always a great idea for a will. A lot of people will put them in there, but by the time you get, typically what I see in probate circumstances, after someone's passed away, nobody's really thinking about that will right away. And, it's like, okay, we got to make plans, and we got to do this. And they have a very nice ceremony, and they do what they think mom wanted done. And, she's buried out next to dad, and they get a will out, and it turns out I want to be cremated and have my ashes spread in the spot, in the ocean or something like that. Then the kids, oh man, we didn't know that. And we didn't read the will. And, it's generally a bad place to put those types of things. It's best to have a conversation with your family and let them know where that is. A lot of people will consult funeral homes and make plans in advance. That's certainly, if you're one of those planners, that's a great idea. You can prepay for some things. All of those homes will have, you can go down, you can sit down with them. They'll talk about all the different packages. Because again, somebody else is going to be making these decisions, and somebody may think, oh, dad meant so much to me that I got to get him this, gold plated casket, where I'm like, hey, don't spend my money on it. Put me in a pine box, don't do that. Right. It helps people make those decisions. So there's some good reasons to talk about, make plans with funeral homes before you go. and you can sit down. They all have different programs and different ways to pay for it, and different ways to plan for it. So you can, I would encourage you, if you really, really want to be that, that planner, go talk to the funeral. Then
Jason,
I think what I'm going to. Oh yeah.
We do have a couple of questions in the chat, which I think if we're at a point where we could address those before we move any further, I think that would be great. The first one is a question asking about power of attorney. Does a person who's being assigned as a power of attorney also have to sign, is the question?
No, they do not have to sign to agree to be a power of attorney. A power of attorney is a conveyance that does not have to be accepted. So I can actually appoint you as my power of attorney. You don't even know about it, but you still have the power. Great question. Okay. And I was going to talk about powers of attorney in a second, but I'll jump to it now.
Okay.
A very, very common question, especially in your industry, are grandma's house is listed, grandma passes away, but it's okay because son has a power of attorney, so the son can take care of it. That is not the way it works. A power of attorney, like I said, is a legal document granting somebody authority that I can do. What kind of authority do I have if I'm dead? The answer is none. So the power of attorney dies with the individual that grants it in most circumstances. That's a general rule. So the powers of attorney do not help avoid a probate situation. They don't stand in place of a will. They go away when the individual passes on. The power that would be with the power of attorney goes away. And so I know you guys see that a lot. It comes up a lot. Common question on the hotline. When somebody passes away, what do I have to do? And I'll talk about that in a second in probate. But that's power of attorney. And I see a community property question. I'll get to that, Chris. That's down on my list. So put a pin in that for a sec. Anything else? Go ahead.
This next one, Jason, was on estate planning and tenancy in common as opposed to joint tenancy. Do you want me to let you talk about that a little bit, and then we come back to the question?
No, that's this fine place for that. That's pretty complex. I don't want to go too far down that rabbit hole, but there is some planning that you can do through deeds. And when you guys all went through your real estate classes, hopefully you learned all the different what we call them different estates. If there was a lawyer teaching, he probably talked about a bundle of sticks. If you need to refresh your memory, that's what he was talking about when he's talking about bundles of sticks, where was different types of estates. And so property is owned in different ways. If I own it simply, I own what's called a fee simple life estate. That means a fee simple estate means I own a piece of property. It's the most common that you see. I've got a warranty deed from somebody. I own it. Now so that's easy. But I can also own it with Cindy, who's not, we're not married, but it's, she's a business partner, and, she and I own it together. Then we both have equal ownership of that. And I get to decide what happens to my half of that property. I can say that, okay, when I die, it goes to Cindy, my partner, or I can say, no, when I die, it goes to my kids, and then Cindy can buy my kids. I mean, there's all sorts of estate planning that you can do with deeds. One of the common ones is to hold property with right of survivorship. And so what'll happen basically just means that while there are two people on the deed, they may not be married, and it's not a community property situation. You can actually put it into the deed to say that when one of them dies, the other one gets the property completely. There's the reverse of that, which is a life estate. You may see that sometimes. A life estate means you have the property for your life. When you die, the remainder of the property goes to whoever else is there. And you see that sometimes in an elderly situation, which we're actually can do in any situation. I can say, all right, I live at 123 Main Street. I'm 85 years old. I'm going to live here until I die. We want to skip or avoid probate, which I'll talk about in a second. So what I am going to do is I'm going to take that house. I only have one kid, so there's not going to be any fight. And I trust him. I'm going to give him my home, maybe sell it to him and get the cash out of it. But I'm going to hold back a life estate, which means I get to live here for my life. He can't throw me out. He can't go to court and evict me. He can't do anything. I own the property during my lifetime. He can't do anything, to get me out of there. But the moment that I pass away, he gets the property and it's now his. And so we didn't have to do any court action to make that happen. It's a very common thing that we see when it comes to deeds and kind of doing estate planning that way. Now, there are some things when you have a life estate, I can't burn the house down. There's certain things, usually they come with certain obligations, and there's hopefully contracts that go along with that things of that nature. But so that was a good question. There are some deed ways to deal with estate planning, but I don't want to go, like I said, too far down that rabbit hole.
Let me go ahead, if I could, and read the entirety of the question, because they are looking, I think, for a specific answer. A big part of estate planning is how to vest title on newly acquired property. Idaho defaults to tenancy in common. However, many title companies are drafting documents as joint tenancy, parenthesis, right of survivorship, end parenthesis, thus not subject to probate. My concern is upon the death of one, the step up in basis may not be realized as it would in tenancy in common. Any advice on vesting?
No, because what they're talking about is when they're talking about when they were talking about the step up in basis and things like that, I think they're talking about tax valuations and depreciation and how that works. And I am not an accountant. I went to law school, so I didn't have to do math. So an important part of any estate planning is to consult with an accountant as well. I always tell every one of my clients, I can legally do what you want to do when it comes to taxes and all that type of stuff. You need to talk to your accountant and figure out what you want to do. If it is a joint tenancy situation, if it's right of survivorship, if it's different things of that nature, just let me know and I'll draft it up. I'll make it happen. The reasons for that tax wise or with ownership, that's your accountant, and I don't do tax law, so I don't want to weigh into that one.
Okay.
Good question.
Then the next question, do you recommend a spouse who might be terminal to do a quitclaim deed to make the transfer into the surviving spouse easier upon death?
Certainly could be. A quitclaim deed is a way to do that, especially with spouses. One of the things I see a lot in my business is once the kids will come to see me and say, oh, dad passed away and now we need to go through probate, take care of the real estate, get his name off of the farm. Well, it turns out mom died 10 years earlier. They never did anything with it. And now you got this title and, different title companies handle that differently. So having somebody do a quitclaim deed is a good way, especially if, a lot of this is morbid talk, right? And I don't mean to talk flippant about that type of situation, but if there's deathbed circumstance where maybe mom or dad are really kind of knocking on death's door there, quitclaim deed can do that so long as they still have the capacity to transfer their property.
Okay. Is there a way to avoid probate either through a trust or will?
Right. So that's great. Let's talk about that. That's kind of where I was going. So probate has a kind of a negative connotation to it. And a lot of people are like, oh, I got to avoid probate. That's why I'm going to do a will, is I'm going to avoid probate. Because in the old days, probate was a bad thing. It took forever. You had to have lawyers involved. Nobody ever wants that. You got to go to court, all that sort of stuff. It is actually the process through the Uniform Probate Code and through, years and generations of refining this. Probate is not difficult anymore. Probate is not a bad thing necessarily. Probate is simply the legal process that we refer to, that where a court is dealing with a decedent's property and figuring out what's to happen with it. You do not avoid probate with a will. You make it much simpler. If you don't have a will, you either way, you're going to go to the judge. The judge is going to look at, what did you own? Where does it go? In a probate situation, really, we file probate all the time, and it's very simple. If you have a will and there's no fighting over anything, probate process is extremely simple. It does take a little bit of time, depending on the county that you're located in and the court load and what they have. In Ada County, we have a specific probate judge who handles everything, and they do a pretty good job of turning it around. It takes a week to get a personal representative appointed. So avoiding probate is not something that you can do with a will. You can do it with a trust, because I'll talk about this in a second when I get to trust, but a trust is a present conveyance, or typically it's a present conveyance. And so the person who dies doesn't own anything, the trust does. And so in that case, you don't need a probate because there's nothing to move, because it's in the trust. But let me finish up with the will, and then we'll go to trusts, and I'm just going to briefly touch on those. So the last thing in the will is the personal representative, also known as an executor. You've heard those two terms are interchangeable. You name that person in the will, and you say, this is the person I want to be. They're basically the person who is just going to do what I just said. In probate, what they're doing is they're collecting all the assets, they're paying all the debts, and then they're distributing what's left over. I mean, that's simple. That's what probate is. Somebody has to be the live body that does that. Somebody has to sign deeds. Somebody has to open up a bank account, maybe, to the final tax returns. There has to be a person to do that. That's the personal representative. A personal representative typically hires a lawyer. And so I work with the personal representative to make sure he's doing it according to the will. He can say, well, the will says this. How do we interpret that? I can help him with that. How do we do the deeds? That's what I do in probate is I help the personal representative. The personal representative is my client when we're doing probate. So the personal representative can be anybody you want to. It does not have to be a relative. It doesn't have to be who you're giving the property to. Some people use lawyers. Some people use banks. There are no restrictions on who can be a personal representative to take care of your estate. So again, we name that in our will because we don't want the government telling us, who's going to be doing those things, because some people are better at it than others. When I'm consulting clients about who to pick, I tell them to pick the kids, the kid that has a good business sense. Maybe one kid is just not good with numbers, you've got, all of our kids have unique talents, right? And some are better at other things than others. So, that's the advice that goes into this. So pick somebody who is, who can do this, because this is pretty much business transactions. Pick somebody who maybe has experience in that, or you feel comfortable doing that for you. Sometimes it's a business partner. Sometimes it can be, anyway, there's a lot of different avenues that can be there for the personal representative. We always do backups as well, because like I said, people draft these things, they don't touch them for 10, 15 years. And you don't know if that person's going to be around. Almost always it's your spouse is the first personal representative. But if you both die together or they predecease you and your spouse isn't around, then that's who your name PR comes in. But again, we just do backups just in case, right? So that when you're doing it 15 years from now, there's always somebody, and hopefully there's somebody on the list that's a little younger that's going to be around. So that's the gist of wills, and I'll ship to trust unless there's other questions.
We've got a bunch of questions, so I'm going to go through them one by one. How do we record with the city to make it official?
Record. So we don't record wills, and you don't record with the city either. You record with a county. So I think the question is more specifically is how does a will become official? It is when you're in the lawyer's office, you will sign the will. The will has to be witnessed by two people. And then it also has to be notarized. And that's a formal will. Now, Idaho recognizes holographic wills, which is literally where you take out a piece of paper and you write on it and say, I, Jason Risch, want my entire estate to go to my two children equally. Signed, Jason Risch, dated, July. That will actually be a legal binding document in Idaho. Not every state does that anymore. It's dangerous, but you can do it. It has to be in the person's writing. They can't type it up and then sign it. There are some very specific, I don't like talking about, because everybody thinks, oh, I can go do this. It's really a very dangerous way to do it. But I've done it before. I've used a cocktail napkin that was written on, it wasn't a cocktail napkin. It was holographic wills work in Idaho. What do we do with the wills after we have them? I keep them in my office. Most of them, clients want to take them home. Nowadays, people have, fireproof gun safes, or safe deposit boxes aren't that popular anymore, but sometimes people put wills in there. Copies are made. So the more copies you have around, I always encourage, look, if you're going to have, your kids, give them a copy of it so they know what's going on and they're prepared for it. If you don't want them to know what's going on, give a copy to a trusted confidant that will know. And we always stamp ours, and we say the original's on file with Risch Pisgah. Here's our address, so that when the kids find it, they know where to go to find the original will. If the original will gets lost or destroyed, I can probate a copy of a will. That's sort of a thing not a lot of people know about. Obviously, we want the original first and foremost, but the more copies out there, the better off you're going to be. We have a will depository here at my office. It's a bunch of fireproof cabinets, and actually, my father did that as well. So there are wills that go way back in there. That we've held for people for a long time. A lot of states are also doing something where you can do a will depository with the Secretary of State. And probably maybe some big cities do this as well. I don't know in Idaho that anybody has done it besides Secretary of State. But if you go to his website, you can click on it, and there's a way that you can say, hey, this is who I am, and I did a will, and this is where it is. So you can actually I think you could probably give Secretary of State a copy of the will, or you can say, I did it with this law office, this is where it is, or, something of that nature. And that's just another way to kind of put it out there to let everybody know about it. Honestly, my clients' kids know, because they're clients of mine. They know, oh, Jason was our mom used Jason for all of her legal work. Let's call Jason. I'll bet you he's got it, or or something of that nature. So we don't record the wills. They do get filed with it when we go to probate. They do get filed with the court at that point in time, but otherwise there's no recording of a will per se.
Okay, and the next one is, can my dad update his will by writing it down and having it notarized without using an attorney?
You don't have to use an attorney for any of this, as long as you're going to meet the requirements of a will. Absolutely, you can do it without an attorney. And like I said before, there's holographic, wills. A holographic will does not have to be notarized. Like I said, if it's all in somebody's handwriting, and I don't want to give all the elements because I don't want to screw it up here and have somebody go do one and then say, oh, it didn't work. It's got to be signed, dated. It's got to be in their handwriting. I think I covered them all, but I don't recommend them, so I'm not giving you legal advice on how to do a holographic will. But the answer to that question is yes, this can all be done without attorneys.
This next one, I think a lot of us would be interested in, because we've got clients that are new to the state. The question is, my husband and I had our estate planning done out of state. We moved to Idaho 3 years ago. Does our estate planning, inclusive of trust, living will, durable power of attorney, etc., is that legally in effect in Idaho? What if something happens to one of us?
Yes, it is legally binding, and the probate is typically initiated in the state where you passed away, or the country where you passed away. I had a client that had the unfortunate experience to pass away down in the Bahamas, and that was tricky. But the probate starts in the place where you pass away, which is usually your domicile state as well. And so in your circumstance, even though it was drafted up by an attorney out of state, it's going to be probated according to Idaho law. And so there's a lot that goes into this, right? Like, so, and I don't want to spend too much time on it, but generally speaking, yes, I would always advise you to go see a lawyer in the state that you're going to be, living in long-term, just to update it, or just have them look at it and say, hey, this is what we did. If you're coming from a UPC state and you're going to another UPC state, Uniform Probate Code, then I can almost promise you nothing has to change, and that it'll be legitimate. So you don't have to, spend a bunch of money going through a whole nother process just because you move states.
Okay. And the next question, does Idaho recognize a ladybird life estate?
I don't know what a ladybird life estate is. Sorry. That's, I'd have to look that one up. Or if you want to give me more into it, I don't know. I never even
if they want to
heard that term.
Okay. If they could type a little bit more information for us, maybe we can address it. That's all we've got right now. So if you want to go on to next section.
Yeah, let's talk. What's a trust? And I don't want to spend too much time on this because I want to make sure I have time to talk about the probate process. Trust, and we can do like a whole hour just on trusts. But a trust is basically you're creating an entity like a corporation or an LLC. You guys all understand what that is, and they can hold property. They can do things. Trusts are the same thing, and a trust is a document. It used to be, we used to do these a lot actually in estate planning because it was a great way to avoid taxes. And so what would happen, and it still is, but because that number's so high, we don't do it much anymore. But there used to be a very common thing called a AB trust will. So you have a will, and then what you can do is you can say, when I die, I want the property to go into trust, because if I die and it's going to get taxed, again, I'm probably going to end up talking too much about this, but so a trust is that legal entity doesn't have to pay tax. So here's the concept, right? You're a Rockefeller, you have billions of dollars, and you have a huge home in the Hamptons. That home is the value of that home is above the taxable amount that the federal government's going to tax. When Grandpa Rockefeller dies, the government's going to tax that property when it moves to Father Rockefeller. When Father Rockefeller dies, it's going to get taxed when it moves to Son Rockefeller. And I'm being sexist by using men's names. I apologize. It could happen with the women, same thing. But that's the idea of this, is that, hey, let's put it into a trust. It never changes ownership, right? It is in the trust, the Rockefeller Trust, and now the trust says the eldest female Rockefeller gets to live and control the house so long as they're alive. So now Grandma Rockefeller gets to decide. She can throw Grandpa Rockefeller out because she's in charge of the estate. When she passes away, it says, okay, the eldest female, that's now, that's Mom Rockefeller. So it never actually changes possession. That is the easiest way to kind of understand a trust, because I'm not moving it, so therefore there's no transaction tax. As clever as estate planning lawyers are, the government has just as clever lawyers working for the IRS. Every loophole we find, they close and tax. So they've found a lot of ways to get around all these different things. And so there's a lot of accounting and tax planning that goes into it. That's usually the reason you do trust is for tax. Well, the way I mostly see the trust is for tax purposes, because you're trying to avoid some taxes, which is, and they can be a great plan for that. Some people just want to do a trust because they do want to avoid probate. And again, if you've got something that's in trust, then I don't have to go to a court to get somebody named PR who can then sign the deed, because it's been in the trust. So there's reasons to do trusts that are as long as, like I said, we can spend hours doing just the trust talk here. Most people do not need a trust. You're going to spend a lot of money on a lawyer drafting up trusts and getting, there are some complexities that go along with that. In the old day, I recently had a bad experience for a family that there was some guy that was going door to door in a farm town down in the Magic Valley, and he was convincing all these farmers to put their property in this trust. It was this pre-printed form, and the thing was not drafted by a lawyer. It was a total mess. It was really problematic. And at the end of the day, it turned out there was no need for that trust at all. They could have just done it with a simple 5-page will. Anyway, so they can be complex. They can cause problems, but they can be very, very valuable. If you have a sizable estate, they're, something that people want to spend, and everybody's different in life. People come to see me and they say, look, I don't have much money, and I don't want to spend a lot of money. I want a simple will. I can do that for them. There are some people who say, look, I've done pretty well in life. I've got a lot of money, and I want to make sure that, things are planned out correctly, and I want to do a trust. There's nothing wrong with that. But mostly speaking, most of the opinions I give to my clients are, unless you've got a very high level of wealth, a trust is not needed. That's my speech on trusts. Like I said, they serve a good purpose sometimes. Sometimes they're, either lawyers making money or they, there's just no reason to do it. Anyway, so that's my trust speech. Like I said, we spent a whole hour doing nothing but that, but I want to move on.
Okay, we've got a couple other quick questions. Did I hear you right? If one passes in another state or out of the country, the probate will be done there?
Yeah, so what'll happen is typically, it's been a while since I've done this, but typically the probate is initiated if it's the state where you pass away. Let's say you own a property in Idaho and you own a property in Washington, and you're living on the Washington side of the border and you pass away. The probate starts in Washington and you die in Washington. The probate starts in Washington, and then you have to do a joint, and you have to open it up here in Idaho and do some things here as well. So if you have to do it amongst multiple states, you can definitely do that. But it's going to be, you're going to be looking at where it was that somebody passed away.
Okay. And this goes back to the question about the ladybird.
Okay.
Okay.
We're going to learn something today.
It is a life estate that the owner retains the rights to sell while they're still living. They are often set up as people age in order to shelter a home and allow it to remain in the family in the event the owners need to go into a nursing home, but must be set up at least 5 years in advance of that in order to allow it to be used in the event they need to get Medicaid benefits. They are legal in Texas, but I know not all states recognize them.
So what they're talking about here is a situation where one of the things the government does for us is the government will provide for us in our old age when we get sick and we have to go into a home. If you don't have money, the government pays for that, and they will pay to take care of you. The government then has a right to come after your property. And so in other words, because it's not right that, the government, maybe you're not liquid, maybe you own $1 million estate, but you need to go into a home right away. And so you go into a home, you don't have any cash, all your bank accounts are drained, all your money's tied up in a complex real estate transaction, but you do have $1 million in assets. You go into that home and the state pays for you to live there for 6 months or a year. to get the care at your end of life. When you pass away and the state has spent, $500,000 for your care, it's only right that the state claw back against, when they finally cash in that $1 million and you get it, it's only right that you reimburse the state. The problem is the states usually take that too far. And well, I should say usually. There are some bad circumstances where states take that too far. Where Idaho has got a pretty good law where they won't. So, for example, grandma and grandpa are living in the home. Grandpa gets ill. Grandpa has to go into a care facility. Grandma's still living in the home. We don't want to liquidate the home to pay for grandma because we're going to put grandpa because we're putting grandma out on the street. Idaho's got a law that says we're not going to make you do that. We'll take care of grandpa. We'll pay for it. But we're going to lien your house so that when eventually grandma's no longer living there, if that gets sold, then we're gonna take our money out of that. So a lot of people want to go through a process whereby they want to take those assets and put them somewhere, give them away, transfer them so that they can go to the government and ask the government to take care of me. I don't have any money. The government doesn't like that because it's like, the reason you don't have any money is because you gave it all away. And so there are some state planning purposes. A lot of people talk about doing that. I'm not going to, because it's, there are those trusts in those estates where people do that, but what you're trying to do is you're trying to avoid using your money to pay for yourself and care at your end of life. I don't think that's, I don't think it's an appropriate way to be, taking all of your money and hiding it from you. If you got the money, use it to take care of yourself first. But anyway, so I understand what they're asking about. So what Idaho does is, yes, Idaho does have a statutory time frame in which they will look back on a gift, and they can, by the way, reverse gifts. If Idaho pays for money for you, and you have just, you had $1 million in the bank and you just literally gave it to your kids, the Idaho can actually go to court and get that reversed and take that money back if it happens within a window of when they provided the support. So that's what that concept is transferring all those assets away so that you look destitute for the government to pay for that. And so that's what they're talking about when they talk about those ladybird estates. But yes, Idaho does have a statutory time that they will look back.
Okay. This one goes back to passing away out of state. Does that mean even if you reside in Idaho but on vacation out of state when passing, but are on vacation out of state when passing?
I think so, yes, but I don't quote me on that. I'd have to look that up.
Okay. And then this one goes back to, I think, the trust. Yes. How would you protect your property for your children but not their spouses? Parenthesis, in case they divorce and now have an interest in the family property and have to be bought out? Question mark.
Yeah, it's a great question. And that kind of gets me to community property. And there's a couple things I do want to touch on here. And we're pushing on the hour, and I can go long a little bit if we need to, but I know people plan. So
thank you for that.
Yeah. So that question, so yes, when we get, and it kind of bleeds into community property a little bit. Idaho is a community property estate. The general rule is anything acquired during marriage is community property. It belongs to myself and my wife. We each own an undivided 50% interest in that property if it was acquired during marriage. There are some exceptions to that. One of the exceptions are gifts, and another exception is inheritance. Anything that you would provide to your children would go straight to them as their separate property. So, for example, if you owned a piece of land and you had one son and, or I think a daughter was in the example, and the daughter's married, when you die and you say, I want my property to go to my daughter, and I just name the daughter, not the daughter and the husband, it's going to pass to her. It's going to be her separate property. She's going to be the only one deeded. Husband can never have, well, Don won't say never. The husband doesn't have access to that property, right? It's hers. Now, there's ways that they can hold that and they can change that, and through a concept called commingling, we can take money. If money becomes basically, put in a snow globe and you shake it up so bad over so much time that you can't figure out what was separate money and what was community money, it all becomes community money. Real estate doesn't get mixed up like that, but you can improve it. So let's say it's a vacant ground. If the community is paying taxes on it, the community can have a claim, for that, because the husband's like, wait a minute, this is your property, and I was paying half the taxes. If they build a home on it, if it's a vacant lot and they build a $300,000 home on it, then, community obviously has access to that $300,000 improvement that they did, plus value over time. So there are some ways that can get screwed up, but generally speaking, anything that's inherited is inherited as separate property. And so the husband would never have, as long as they work to keep it separate, the husband would not have a claim to it. There was a question, by the way, we're right along that track. Before we came into this class, somebody had emailed and said, well, how can I leave it to my wife, but I'm worried about my wife getting married again and then that guy getting access to it? Same situation. If it's deeded to her, it's her separate property. Just because she marries again does not change that. Now, once you pass away and give property to somebody, it's theirs. They can do whatever they want to do with it. So she can deed half of it to him. She can sell half of it to him. She can sell it to a total stranger. A lot of times I get clients that want to control that and say, oh, this house has been here for generations and I want to make sure it stays generations. When you're dead and gone, there are ways you can do that. You can spend a lot of money, but be prepared to pass away and go on to the great beyond and enjoy your afterlife. And don't worry about trying to control what's happening down here, because you'll just bang your head against the wall for it. But there are ways that you can do that. Trust would be one of them, right? If I put the property into a trust, then we let the wife live there. She passes away and then goes to the kids. I've seen that before. So that's a question. So I know there's some other ones. I want to touch on probate really quick. I've kind of mixed it in here, but I want to talk about what that looks like. Somebody passes away. They come to me. They say, Mom passed away. Here's her will. We do a lot of paperwork and we go to the courts and we basically submit that will to the court. And we say, court, we're asking you to appoint this individual personal representative. You can see they're named in here, court. I don't know what the courts do behind the curtain, but theoretically they actually read the will, they look at it and they say, okay, yes, that person's the PR. And they sign a document called letters testamentary. That is the document that gives the power to the PR. So now the PR can sell that property. When you go to closing, the title company is going to want to see that piece of paper that is the letters testamentary. That's what you're doing with probate, is you're getting that letter. Once you have that letter, you have been appointed basically to act for the deceased, and your job is to carry out the instructions in the will. You collect all the assets, you pay off any debts, and then you distribute the assets where they want to go. And that's probate in its simplicity. There are various forms of probate. There is very formalized probate where there are schedules of property given to the courts. You put values to things. The courts look at them. You can get the court's blessing and approval on distributions. They can be very, very formal in open court hearings. You can go through a lot of that. They can be very, very informal. In Idaho, we recognize some summary proceedings for small estates that don't have much for assets and for surviving spouses. Those are a typical probate, though. Looks, those could be very quick. A typical probate, and it's called an informal probate, and it does just what I say. You go through, you get that piece of paper, you go through the process. You don't have to file an accounting at the end of it where you tell the court, hey, this is what I did. You can actually do a closing where you can get the court to bless it. And like I said, you could go to the court and explain, say, look, here's the will, see where it says Junior was supposed to get the hot rod. Here's the title that shows I signed it over to Junior, and then the court can do all that. Another thing that we do when we do probate here in my office is we will publish. You'll see those in the newspaper that, so-and-so has passed away. All creditors, please come forward. We do that because that gives you like a 4-month window. And if the creditors don't come forward in 4 months, they can never come back against an estate. So that's another reason we do probate, is to resolve all that, right? Visa can't pop up 6 years from now and say, oh, hey, by the way, you didn't know this, but your mom ran up a $100,000 Visa bill and we're coming after you for it. If they didn't come forward in that time frame, they're forever barred from doing so. So that's probate from kind of start to finish in a down and dirty, quick sort of way.
Thank you.
Okay.
I've got a couple of other comments. This one is that this has been super helpful, and thank you. We are interested in using you, or if we are interested in hiring you, where are you located?
My practice is right here in downtown Boise. I am literally across the street from the Supreme Court building on Jefferson. It is Risch Piska, PLLC, and you can Google that and you can get all of our information from there. And we do, like I said, we do estate planning. We'd be happy to have you as a client and see what we can do to help you out. And, the next question is, well, how much does it cost? It depends on what you want to do. They start, and like anything in your industry, you can shop, you can find people that do it for you. You can find stuff on the internet that you can try to use, fill out some forms. Those almost constantly get screwed up. I've seen some really bad ones, and all you're doing is leaving a fight for your kids. You're not even around. It's not even going to be your problem. The fact that you didn't spend money on a lawyer to put a will together becomes your kid's problem. And when there's a fight, if there's assets, even if there's not many assets, and you get kids that start fighting over this thing, unfortunately, I've gone through litigation. it gets very expensive and it gets very time consuming, and you want to try to avoid that. So how much does it cost? It depends on how, you can do a simple package to where we can do some very complex planning. I've done wills for folks that they want to say, well, I want to leave all the money in my kids, but I want to make sure they graduate college first. Okay, well, I can do that. Let's put that language in there. But what do you call a college? Does online work? Are we talking brick and mortar? What if they go to BSU? Are we going to call that, college? That's go Vandals, right? That's my shot. I had to put it in there.
I knew you had to get it in. We've got another question though. This one is interesting. To clarify, if one is thinking they need a trust, should they first consult a CPA to determine tax liability issues and then an attorney to complete the trust?
Absolutely. You can do both of them at the same time and they may all have different. And if an attorney tells you need a trust and you don't have millions in assets, you might get a second opinion on that. And again, some people practice differently than I do. I don't typically do wills for folks that, unless they have more assets, because you're going to spend a lot more money doing them. Trusts have to account for a lot of different things, but there are lawyers that have, sort of form stock trusts that they can use for you. So, it's really up to each individual person, but don't just have a lawyer tell you, oh, you need a trust and you have to go get one. Ask why. Why do I need a trust versus a will? And, and see what they say, and then maybe get second or third opinions. But yes, an accountant and lawyers should always be part of your estate planning process.
Okay, and this one again goes to the same topic. I understand a trust cannot be contested, at least not easily, but a will can. Is another reason to do a trust, and do you do them?
No, there's no, I can contest a trust as easily as I can contest a will. There are some more specific statutes, and I know that say if a will looks like this, boom, 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 it's presumed to be legal, and now it's up to the person to challenging it. They have to meet a very high bar. A trust doesn't necessarily have all those provisions with it, but again, I don't. My practice doesn't involve a lot of trusts. So do I do them? Yes, I've done them before, but if you're looking for one, unless you've got millions, like I said, I don't recommend doing that.
Well, that's the conclusion of the questions.
Okay.
Jason, we can't thank you enough for everything you've been able to, all the time you spent and everything you've been able to get covered in the time. So I'm sure people will probably be reaching out to you with a lot more specific questions to follow. It does look like we may have one more question here in the chat. Nope, just thank yous.
Oh, hey, Chris, that's Chris. I'm sorry, Chris, I put your question off for later. Did I get to it? I can't remember what her question was. I think she had something and I said, I'm going to get to that, but I want to make sure I got to it.
I'm looking to see here if we did. Let me keep backing up. It froze for a minute.
Oh, I might be able to.
I apologize. Here we go.
Chris was asking about the
community property. Yeah.
Okay. All right.
And we didn't have a clarification, unfortunately, on that. So I think that does cover the questions. And once again, a fantastic, fantastic webinar. Thank you for all of your time and for all the help you give Idaho Realtors every single day. So
sure.
Thank you everyone for joining us.
Yeah, you bet.
Thanks, Jason.
You bet. Thanks all.
Bye, everyone.